We live in a modern-day Handmaid's Tale. The weights are tilted unequally. Women still don't have their bodily rights. India remains one of the few countries in the world that does not treat non-consensual sex within marriage as rape. If the wife is not under 15 years of age, sexual acts by a man with his own wife is not rape. And the latest word by the High Court further confirms this.
स्प्लिट वर्डिक्ट जो है ये सोसाइटी का सिचुएशन को दर्शाता है, क्योंकि ये मानना कि इस मुद्दे पे सिर्फ एक ही राय हो सकता है इज नॉट पॉसिबल। लेकिन मैं ये भी क्लैरिफाई कर देता हूँ कि कोई ये किसी का पोजीशन ये नहीं हो सकता है कि मैरिज के अंदर या मैरिज के नाम पे कुछ भी हो सकता है। पोजीशन किसी का ये है ही नहीं, ना हमारा कोर्ट के सामने ये था।
Section 375 of the Indian Penal Code 1860 says that sexual acts by a man on a woman against her free will or consent would constitute rape. But there are two exceptions to this. The first exception says that a medical procedure or intervention shall not constitute rape. And the second exception states that sexual intercourse or sexual acts by a man with his own wife, if the wife is not under 15 years of age, would not constitute rape. This provision is being constitutionally tested.
Also, let us not forget that rape in this country also includes anal sex. It also enforced anal sex, right? It also includes forced facilitation of gang rape. And husbands are exempt from all of this.
The first petition challenging the constitutional validity of the law was filed in court 7 years ago, that's in 2015. The petitioners have said the law violates a married woman's right to equality, the right to life with dignity, and the right to self-expression. They also pointed out the contradiction in this law. Slapping or killing one's wife is criminal, but not raping her. But the government disagrees. The Delhi government told the court that remedies for marital rape already exist. Under the Indian Penal Code, offences such as cruelty and grievous hurt are punishable. It justified the provision by stating that striking it down would lead to the creation of a new offence. But the petitioners retorted, the offence of rape already exists in Section 375. Removing the exception would just remove the protection married men receive from being prosecuted for rape. In 2017, the court affirmed the view that refusing to participate in sexual activity is a part of the right to personal liberty under Article 21 of the Constitution. It was further observed that marital rape does not destabilize the institution of marriage. The latest hearing was being heard by a two-member bench, but the judges delivered a 1-1 split verdict. The Delhi High Court has now said that the matter will have to be considered by the Supreme Court of India. According to Justice Hari Shankar, Exception 2 to Section 375 does not violate the Constitution as it is based on intelligible differentia. On the other hand, Justice Shakdher said that the exception is violative of Article 14, 19 and 21 and therefore should be struck down.
For more informative videos like this, keep watching India Today News Mo.